Roman Storm, the developer of Tornado Cash, been found guilty of the same thing that the developers of Samurai Wallet were found guilty of. And interestingly enough, what all of these guys are being hung with is the exact thing that the Blockchain Regulatory Clarity Act or Certainty Act is supposed to get rid of, is that everybody is being charged with being a money transmitter. And so this is the jury in New York who has found Roman Storm guilty of this, and we should look into it a little bit more. I know you had a chance to read through the article a bit. What's your take on what's happening here with the developers of these various technologies, particularly the privacy ones that have come under fire recently and that we've gotten these verdicts for in the last week or so?
Well, the first thing that catches my eye when I look at the charges against them are that they're not being charged with being with violating their money transmitter license or being a money transmitter. They're being charged with a conspiracy.
Well, I think Roman got hung on being an unlicensed money transmitter, as in what they're saying that the activities he engaged in was money transmitter activities, and he didn't have the appropriate licensure.
Okay.
Did I miss that? Maybe I got it wrong. That's what I thought he was.
No, valid. I was actually, I was thinking about the two charges, the more serious charges that carried penalties of 20 years instead of 5 years, that the jury the jury hung itself on, that couldn't reach a verdict on.
Yeah, so there were several charges that were levied against Roman Storm, and the jury was not able to come to a consensus on this. So, the mechanics of this are they have to be unanimous. The foreman has to decide that he wants to actually render that verdict, and they only were able to do that on lack of licensure, but not on these other criminal conspiracy things that they tried to pin on him.
Well, the reason I bring up this, the use of the conspiracy, is because the federal government loves to extend its jurisdiction, extends its reach in charges with conspiracy. When the federal government wants to charge someone, or prosecutors want to charge someone with federal charges for, say, murder, they can't charge a person with murder because it's not the jurisdiction of the federal government. They have to rely on conspiracy charges. So I've always been dubious of the federal government's fervor to seek out conspiracy. That to me is a degradation of liberty, and presumes to tell people what to think, and equates communication with action. So,
well, conspiracy is such an interesting one as well, because conspiracy in some ways implies that there's more than one person involved. It's like that. It's very common in lots of endeavors. I mean, conspiracy is, just like a gathering of individuals together in the broadest sense of what that would actually mean. So it seems fairly easy to pin that one on anybody, except for in the case of Roman Storm, pretty hard to get him on a conspiracy charge if there's only him.
Well, great point. And it would be interesting if the federal government had to come up with the other conspirators in order to charge conspiracy. And I don't know if that's the case with Roman Storm. But regardless, I'm always wary when I see conspiracy charges with the federal government, and they love to bring those charges. But again, the federal government reaching into the minds of the citizens of the states, I think, is a problem. It's one that we've come to accept, but we need to think about the government's the ability of the federal government to presume They know what's going on in our minds, or that communication uh, is on the same level as or is on the same level as action. So when I think about the ideals of liberty of Americans, um, for through the history of America, I just don't know that that is congruent with what the American experiment was about. Um,
So I mentioned this, and we did cover this in a previous show, but it's worth bringing up, especially considering what's going on with Samurai Wallet and with what happened with Tornado Cash, is if you look at the provisions in the BRCA, the Blockchain Regulatory Certainty Act, you can see that it specifically precludes anyone from being treated as a money transmitter or being accused of this. This is the bill that Tom Emmer introduced back in, I think it was 2022, has been reintroduced into this Congress. I'd be shocked if this doesn't actually get through the Congress. But if this had been in place, I believe both Tornado Cash and Samurai Wallet would not have been able to have been charged or convicted with the thing that they just got charged and convicted with.
well, and bravo to Tom Emmer for seeking to curtail I mean, the other, well, because we have the federal government loves to operate on two concepts: conspiracy and transmission. So here we have, their other their other whatever method that they love to focus in on, and that deals with transmission. Again, this goes to the limits of their jurisdiction. So. Um, at one time, we thought the federal government was going to be concerned um, with the states, and they have broadened their reach by saying, oh, when people are operating between states, the federal government has an interest in stepping in. So this is how they broaden their powers outside of those enumerated powers that nobody knows about that exist in the Constitution. So bravo to Tom Emmer for trying to curtail the reach of the federal government. Uh, it, it I, I don't know what to say. I find this these charges and convictions in Samurai and in the case of Roman Storm seem to me to be unjust. And and I talk a lot too about relying on juries.
Yeah, tell me a little bit more about what your take on this with respect to the jury and what happened with the where the jury foreman could have done something in this case, because you always have a very interesting take on the power of juries, what juries are capable of doing, and you always laser in on the jury foreman, which I think is so interesting because this is usually a job that nobody wants. If you end up on a jury, being elected the foreman seems like an extra burden on top of, oh man, I have to do this thing, I have to leave work, I'm not really getting compensated for it, and now I have to be this extra position that's responsible for delivering the verdict. But there's a lot of extra power that comes with the jury foreman. And does it put you in a position above the judge itself?
I mean, I think that the American concept, and this was hazy at the time of the establishment of the judiciary. Um, Also, to go back to the Constitutional Convention of 1787, the judiciary was not something that was discussed at length, but there were talks about um, the limits of government, the notion of what a government without a president, or I'm sorry, a king was to look like. And mind you, they had an eye on England when they were forming these notions. And the legal system in America is called an adversarial system as opposed to an inquisitorial system. Now, and this should invoke notions of inquisition in our minds too, and that notion of inquisition is that there is someone who can presume to know our minds. Now, in political organizations that are organized around the notion of a shared God or shared moral code, and some person being able to bridge that notion of God, or to have the authority of God, the Pope or a king or a God king, then you can have an inquisitorial justice system. And if you think about how the system in Britain or England works, those judges who sit on the bench speak for the king, and so they can make a decision because they have the approval and power that's granted to them through the king. Well, when the founding fathers were talking about how to set up a system that did not rely on a king, they came up with this notion of the adversarial system. And so, and for an adversarial system to function, there needed to be a triangle of representation. There was somebody who argued for one party, the prosecution, possibly, the government, or it might be a civil case. There was someone who argued for the defense, and then there was somebody who uh, was was the I don't know how to put it, a judge that ruled over the courtroom, that kept the discussion fair, that observed the rules.
The neutral party who's supposed to be there just to make sure that whatever's happening proceeds according to order, and that nobody's getting out of handed. We don't end up in a fight, a fisticuffs right there in the room itself, which is why we've got the bailiff or whatever, right? This is what's
exactly. Yes,
because it used to be that we had swords and we'd fight duels and stuff. We're trying to avoid that in the courtroom.
Well, yes, or at least make sure everything's fair. And this was all supposed to take place in a group of their peers. So when the notion of the adversarial system this is when juries become, to me, are at the forefront of, or so deeply tied to this notion of an adversarial system. Now, as the justice system, and again, this is they're sort of making it up as they go, but as the United States accepted, ratified the Constitution, and began to operate under it, they also put the establishment of the federal justice system to the side, and that was picked up by the First Continental Congress. The first Congress under the Constitution, and they, the head of the Senate at the time, and now I can't think of his name, wrote the Judiciary Act of 1789, and that came into being. But at the beginning, we actually had, in, I believe, the fourth case that came before the Supreme Court, there was actually a federal jury, and John Jay, who was the Chief Justice of the United States at the time, when giving advice to that jury, he said to them, what was his name? Well, anyway, John Jay said to the jury, whenever they were entering for deliberation, he said that juries can, of course, decide matters of fact, but not matters of law. And this was not how everyone accepted the power of a jury. Thomas Jefferson believed that, and many others, especially the anti-federalists who we've forgotten, like Patrick Henry, thought that juries could certainly decide matters of law as well as matters of fact. Now, it's become accepted today that juries only decide matters of fact, but that has never been settled, and there are certainly juries who have taken it upon themselves to that they they get to decide matters of law too. We had a judge from Minnesota who told us about a jury doing exactly that, and the prosecution or a member of a jury deciding that they thought a law was unfair, and so withholding their vote and hanging the jury. And the prosecutor wanted to turn around and charge that member of the jury. And this upset many members of the political apparatus and the legal apparatus of Minnesota, and that those charges were never brought. And so we can see a little bit there the immunity of the jury and the possible power of a jury. And I think this is something that is an unused power and a check on judges um, abusing their power in the court to become especially partial towards prosecutors and the prosecution.
It seems that way. It seems that what we have now is the judges and the prosecutors are almost on the same team, and the jury has been regulated to a very small role. It seems like the whole idea of this adversarial neutral ground has somewhat been lost, with the judge and the prosecutor acting in tandem with the bailiff and in the security state apparatus. It's almost like what needs to happen in this country, especially in New York City, since this seems to be the place where all of these really important cases are being tried. I'm not exactly sure why New York claims jurisdiction over some of these things, nor why it seems that the jurisdiction findings keep going their way. But we need to have a big educational process happening in New York so that people who find themselves on these juries realize how much power they've really got.
Well, and when I think about the juries operating with more power, we have this notion that the judge can call the prosecutor or the defendant or the defense or a witness into contempt. But I don't understand why it's not the jury that is that may decide where there is contempt, and it may be that the judge can bring that to the jury and say, I think contempt is going on here with the defense or the prosecution or witness. But it would seem to me that though the other participants in a trial should also be able to call a judge into contempt, because if this is to be an adversarial system rather than an inquisitorial, they should all be subject to that. And to me, the proper sort of decentralized bottom-up notion of rule, democratic rule, would be to give the decision of contempt over to the jury. So someday,
is there any power that the judge has over the jury in this sense? Like, it can the judge actually, or the prosecutor, do anything to the jury once they've been selected and seated and the foreman has been elected? I mean, maybe some sort of if they're acting in an unruly way or disturbing the court in some fashion, but other than that, do they have some sort of immunity from any type of participation in the trial itself? Can they actually have something happen to them as a result of their being in the jury and issuing some kind of a verdict?
I mean, I have never heard of a juror being called into contempt. The only thing that I've heard of is judges dismissing jurors, and so.
But that has to happen at the beginning. You can't, once the jury's been seated and everybody's in. That doesn't happen.
I mean, whenever a judge, forbids a jury from speaking to the press or reading reading the public, whenever a judge restricts the communication of a jury so that they aren't subjected to ideas or evidence or arguments outside of those being put forth by the adversaries, they dismiss jurors. This is why there are extra jurors that are often sitting in the jury pool. So no, I think I don't know how common it is, but certainly jurors are dismissed during trials.
And when the judge really cares about that, they usually sequester the jury. That's when if they have concerns that they're going to be unduly affected by the press or things that are being said, then they're like, well, we're just going to make sure that you can't see that stuff, so we're going to lock you in a room.
Well, but sequestration isn't always physical. Sometimes the court can't afford it, or the sequestration is supposed to be imposed imposed by the jurors themselves. They're supposedly going to promise that they didn't that they're not going to speak to reporters, or they're not going to read the newspapers. But if they if one of the other adversaries, the prosecution or defense, can prove that they have been doing so, then they are removed. And sometimes they also find out information about jurors.
Can the foreman object to that? What is the power of the foreman here? Because I'm kind of curious about this. These are enumerated powers, because you said that the jury could find the judge in contempt. Would it be the foreman that would be able to do that? You couldn't just, as a rank and file member of the jury, find the judge in contempt. This all has to go through the leader of the jury.
I mean, I'm not sure if this is written down or this is an understanding, but I've just always imagined, or not always, but I imagine someday that we're going to have 12 Angry Men, or To Kill a Mockingbird, but the or what was it with Tom Cruise and You Want Me on That Wall?
A Few Good Men.
A Few Good Men. I mean, another great one. But we've yet to see sort of the public discourse exploring the power and the limits of a jury. I talk about the foreman because there must be there must be a point of contact between the jury, this democratic body, and a and the adversaries of the court, or the court. So, but I imagine, some great injustice being portrayed in a movie, and the jury being upset about it, and the foreman standing up and saying, "You, sir, are held in contempt." I'm not sure. I don't know if it's ever happened.
The bailiff would have to enforce at that point. I mean, what would really occur here? I can't imagine how this would actually play out. The judge looking aghast and saying, "All right, who's supposed to determine whether you're correct or not?"
I mean,
the judge acting as the arbiter for these various accusations.
I think about the Tina Peters trial, when the prosecution said, or the defense said, the prosecution brought evidence that was proved to be wrong. I'm paraphrasing all this, but in the closing statements, the defense said the prosecution brought evidence and made allegations that were proved to be wrong, and the prosecution stood up and said, "I object. It is against the rules of the Bar Association of Colorado for one attorney to call another a liar." And the judge said, "Sustained." If I'd have been on that jury, I would have said, then the bar is wrong. If the facts of the
if the shoe fits, wear it. That's
if the glove fits, wear it. Yes, if the facts prove that one of the adversaries were lying, then why do we rely on the group of other lawyers outside of that courtroom to dole out the punishment? And I think this is a problem, that if juries understood their power and could hold those adversaries in contempt, then we would be less likely to see the prosecution or the defense lying. But I've never seen that happen. So,
well, these are rules of decorum, and it's the lawyers are officers of the court. I mean, they have a duty to the court itself, and this is why oftentimes we'll see lawyers not taking on certain types of cases, not taking on certain types of activities because this is their livelihood, that they have a duty to operate in a certain fashion. And so, you can see that this playing out within the context of the courtroom is because these guys, are part of the system itself. If we're thinking about a movie like The Matrix, I mean, they're part of the system. They're Agent Smith, regardless of whether they're on your side, because they could find themselves on the other side very easily. They're there to act as, a member and standing within the court, and they're trying to apply the rules of the law as they're written down.
And one, I should also add that I love especially Western history. There were certainly law juries, and especially in trials in the West in our history, that understood that that their decision was that they had the power, and were not well disposed to be put in their place by the adversaries of the court, and often said, this law is ridiculous, and regardless of the facts and the narrative that are put before us, we don't we find this law to be legislation that was enacted by people who don't represent what reality is. So we're going to go our own way in the finding of our verdict, and the judges couldn't do much about that. But that also, when you start digging in, and you think about things like civil rights and the abuse of people moving in and taking over an area, it gets pretty muddy. But again, this is where I think the beauty of liberty and the notion of moving around was a great redress to that. So if you had some terribly corrupt people who are packing the juries and abusing justice, well, the answer once was not to fight them, but to move somewhere that you found more fair. There is a political philosopher, Lysander Spooner, who I love, who thinks about this at length, and he lived in he died in 1887. But if you're interested in some of these ideas, they're not new, and I mean, you can also go all the way back to Thomas Jefferson, and think about what some people call jury nullification, or the balance of power between juries and the advocates of a court. But it's always interesting to me when I see us turning to legislatures to write down more things, to supposedly tell the judicial system what to do, when we have a much more decentralized and much more how do I put this? There's a lot of cases that are heard every year. So if juries understood this power that they had, we could see a lot quicker change coming to government. There's something else that I was thinking of as we're having this conversation, because we're talking about a federal, and I'm sure that we said trial. Did you know that the federal government, or the federal government, the federal courts, hold tribunals? They don't hold trials. Ever notice that?
What's the nuance difference between a tribunal and a trial? The thing that comes to mind is tribunal usually has some military connotation. That's the first thing that comes to my mind.
And you're absolutely right. So the military also holds tribunals. Well, what has happened in the military, people have entered the military or been voluntarily or been conscripted against their will, but they've given up the authority or the autonomy of their body. So a tribunal is, in the case of the federal government, you can imagine, is where the states had originally either given up their autonomy or were going to enter at will. Now, we've talked about ex parte or ex parte decisions in the past. Ex parte Milligan, ex parte Merriman,
Merriman.
yeah, ex parte Vallandigham. These and the ex parte means that that the judge was issuing a ruling from somebody who said, "Well, I'm not going to go to court. I've I'm I don't uh, that sounds like a stacked house against me. Why would I show up to that?" So they could not compel um, uh, the persons at who uh, who the ruling or the hearing was with regards to enter into the courtroom.
I mean, is that really possible in this day and age? If somebody brings you up on charges, say in, some district of New York, you can't just not show up. Like, you can't just say, I'm not going to show up ex part. Like, is that right? Can you do that?
Depends on the person. If you're the governor of a state, if in Texas we currently have um, we currently have the governor of Texas asking the FBI to go out and find 50 Democratic congressmen who fled Texas because they don't want to um, be collected by the state troopers or the Texas Rangers and forced into the Capitol. Um, Forced in the Capitol, so a quorum is established, and the Republicans can force through their redistricting. Why
This
did they?
happened. This happened in Minnesota too. So what happened in Texas is they sent out their runaway slave catchers here. They're out there to get these guys.
Well, and that's actually what the Constitution was written to do. So that was a notion that applied to people who were second, third, fourth, fifth, a much lower class. We still have that class system today. If you think about it, there are regular citizens, and then there are people who enter into government, and uh, there are also maybe a class in between there, the bureaucrats who work for the government. So as Texas takes those notions of the power of the federal government uh, to return people to the state of their origin, so those people are then under the thumb of the coercion apparatus of the state. Is that going to hold? I don't know if it will, um, but we're about to find out. Um,
So maybe if you're a person who is in a position of power, perhaps if you're a sitting member of the legislature, governor, you're protected by one of these ex parte things. But this is probably not a strategy which is available to the average citizen of one of these states.
no, I don't think it's available to a citizen, but it we'll see how this plays out. I'm very interested to see if the federal government is going to sidestep this request by Governor Abbott, or if they are going to go out and apprehend those legislators in Illinois and return them. Um, I don't know. I don't know how that's going to work out. Meanwhile, because we brought up sort of this autonomy of the states and the power of the states. Whenever Trump was sending in the National Guard and the Marines into Los Angeles for the supposed Los Angeles riots. And I don't know if you've been tracking that, but Governor Newsom sued Donald Trump and said the National Guard is under my control, and you only get to assume control of it under certain conditions, and those
How did
conditions.
that play out? Is that resolved or is that still ongoing?
That's resolved. And
Okay, well, I missed that one. So
it was,
Newsom won.
yeah, absolutely. Absolutely. Um, so so as we see states begin to remember um, uh, their powers over the bodies of citizens, when I see the federal government making these moves, in increasing their power on the backs of conspiracy and transmission. I think that has been a slow disaster in their regard. And this is because the ideas of America were for local control and local rule. So I was not surprised to see this decided in their favor. And it doesn't matter if you're Republican or Democrat or what party that you come in on. Politicians like centralized rule, because they can they have somebody else that they can, somebody else's power that they can operate on. But by and large, American people, and I think people of the world, move towards, when we talk about democracy or even republic or whatever our ideas of political order are, we want to decide more locally. So I always expect that to win out in the long run.
Well, it's a fascinating discussion. We started in the world of crypto, moved through some historical stuff, brought it back home with a recent decision about what's happening with this fight over centralization versus decentralization, local control versus centralized federal control. I really hope that one of the reactions that we see from people, from juries, is to try to bring it back as local as possible. I think even though you're likely to get into a fight with your local city council, at least it's someone you can look in the eye and somebody you might know from the neighborhood versus some faceless bureaucrat that you have no contact with and is exercising undue authority over you. This might be the swing that we need to try to get this country going back in the right direction. And I applaud this decision here. Thanks for bringing it to my attention. I knew that this was happening, but lost track of it in the results. So sometimes these things don't resolve very quickly, but it seems like this one resolved quite fast. Any last thoughts? But otherwise, I think that's it for today.
Well, there's also seems to be this there seems to be this thread of coercion versus liberty, and I hope that America remembers that the answer to coercion is not always more coercion, but to go somewhere that you find more fair. Liberty means moving about like free air, and so we don't always have to. Because I think about American foreign policy in this regard too, and our wars around the world. At what point was it American to say, we don't like what you're doing, we're going to change what you're doing, instead of saying, go somewhere where you find people of like minds, and liberty is the answer, not coercion.
All right, and we'll see you next time on FOMO.